To the inquiry. My name's Alistair Edwards. I'm a reporter with the Planning and Environmental Appeals Division, and I've been appointed to provide a recommendation to ministers on the Section 36 application for 12 wind turbines at High Clachaig Forest. Could I just confirm everybody can see and hear me? Yes, brilliant. Everyone should be well versed in proceedings and the arrangements for hearings now. Consequently, unless anyone has any administrative questions or questions about process, I suggest that we begin proceedings today. Any questions from anyone? No. And can I clarify that everyone is content to being filmed today? Just by a raise of hands. Yes. Thank you. Right, can I ask each of the parties to introduce themselves, starting with Mr. Fraser and his team?
Thank you very much, sir. As you know, sir, my name is Vincent Fraser, King's Counsel. I'm instructed by Mr. Gary McGovern from Pinson's, and he will be effectively taking the lead in this matter this afternoon, sir. And I also have Ms. Ellery Davis, who I think you can see on the screen.
Thank you. Mr. McGovern, do you want to introduce the team of people around your table?
Yes, happy to, sir. My name is Gary McGovern. I'm a partner with Pinsent Masons, instructing solicitors on behalf of the applicant. I'm joined in this room by my colleague, Winston Roberts, also of Pinsent Masons, and sitting to my right is Catherine Taggart, who is a technical consultant with AECOM, who are involved in the EI environmental impact assessment process. And sitting next to Ms. Taggart is Ms. Meldrum, who is a project manager with RWE Renewables, the applicant. And joining us virtually, as Mr. Fraser mentioned, is Ms. Davies, who is also an employee of RWE on behalf of the applicant. Thank you, sir.
Thank you. And yourself, Mr. O'Carroll?
Good afternoon. My name is Maurice O'Carroll. I'm instructed by the Council in this inquiry. I appear today and I am accompanied by Mrs. Arlene Knox, Planning Department within the Council. Mrs. Knox will be taking the lead on discussions today. Perhaps with some limited involvement from myself. Thank you.
Thank you. Well, we've reconvened this afternoon to have a hearing on the conditions that would be imposed or could be imposed should ministers consent the Section 36 application. We've gone through item 1. I take it, does everybody have a copy of the agenda?
Yes.
Yes, okay, brilliant. So moving on to item 2, progress and overview. I assume that core document 10.014, that's the most up-to-date and as agreed as it can be set of conditions. Is that correct?
That's correct, sir.
Well, if we move on then to item 3, conditions to be attached to the Section 36 consent, you'll see in the agenda, my questions are set out quite plainly, but firstly, is it necessary for us to have a condition stating the duration of the consent? Mr. McGovern first.
Yes, so that would certainly have been the convention in the past. However, we'd flagged up in drafting note 2 of the schedule of agreed conditions that in recent times the practice of the Energy Consents Unit has been to specify the duration of the Section 36 consent in the body of the decision letter itself, rather than setting that as a condition of the consent. I'm not sure they've ever expressed why they've moved from one practice to the other, but there are several examples of that you'll find amongst the decisions that are in the core documents. For example, Energy Isles, which is CD 006035 and is the most one of the most recent decisions that have been issued. You'll see the approach that's been taken there on page 20 of the consent, and the duration of the consent is specified in the decision letter itself rather than as a condition. And the same applies, you'll see that also, to give you another example, in the Sanker 2 decision, which is CD 006021. So we're anticipating that the duration of 35 years will be dealt with as a limitation expressed in the grant of consent rather than as a condition.
Thank you. And how from my understanding, would that be controlled or enforced if the wind farm is to go beyond the 35-year period?
Well, effectively, sir, under Section 36(5) of the Electricity Act, a consent granted under Section 36 may continue in force for such period as may be specified in the consent, and therefore the consent to operate the generating station would fall away after the specified period, and thereafter any further operation would be unlawful according to the terms of the Electricity Act.
Thank you. Would parties have any objection, though, if a condition was imposed on the duration of consent?
So I would have no fundamental opposition to that. I suspect the Energy Consent Unit may stick to their current approach. I think, sir, as I say, there's been no published reason given for this, but I suspect the reason they've stopped attaching a condition is to do with the provisions of Section 58 of the Town and Country Planning Act, and the provision relating to planning permissions are granted for a limited period of time, which are then not subject to the provisions relating to implementation of planning permissions. Certainly, but the application is based on there being a 35-year operational period, so we have no issue in principle as to how that effectively is secured, whether that's done in the manner that the Energy Consent Unit have been doing it recently, or whether it's done by condition.
Okay, any comment from the council on that particular matter?
I think just to say, sir, that the council wouldn't have any objection to that being secured by a condition if it was considered necessary. That's all. Thank you.
Do parties have any further comments in terms of the preceding Section 36 conditions? Were you all content with those? Mr. McGovern?
The applicant's content, sir.
And Mrs. Knox?
The council's content, sir. Thank you.
Now, moving on to the conditions to be attached to deemed planning consent. That's item 4 in the agenda. What I'm going to do, obviously, in the list of questions, I've gone to specific conditions. But if there are any conditions between those, please flag them up to me and we can discuss them as we go through. In terms of condition 2 and subsequent conditions, there is reference to the EIA report. And simply I'm asking, is it sufficient to use the definition at the end, or should each reference to the EIA report be dated? Mr. McGovern.
Yes, sir. Our position on that would be that the definition is sufficient in this case, and there's no need to repeat the dates throughout the conditions, sir.
Mrs. Knox, do you agree?
Yes, sir.
Thank you. And then throughout the conditions, there's reference to unless otherwise agreed in writing by the planning authority. Now, I wonder, is that particular terminology, is it necessary and is it transparent in terms of future consenting of amendments? I'll ask Mr. McGovern first, then I'll come back to the council.
Yes, sir. Our position would be that the wording is necessary, and it provides a necessary degree of flexibility to respond to any change in circumstances. Where that wording appears, I think I'm right in saying that it relates to conditions where details are to be submitted and approved by the council. So the unless otherwise approved would only be relating to matters that have already been previously approved by the council, and it's allowing for the possibility that some of those details may need to change. Any such further approval would be in writing, and therefore would be a matter of the planning register, and therefore it should be a public document, or certainly one that could be obtained. So I don't think there's any issue in terms of be accessible to members of the public. So what the wording couldn't do would be to allow any committed mitigation to be dispensed with by the council, or to alter any of the fundamental parameters of what's being authorised. So.
And Mrs. Knox, do you have any comment in reply?
The council agrees, sir. Thank you.
Any commentary on conditions 3, 4, and 5? No.
Good.
Okay, moving on to condition 6. Would that condition apply the most up-to-date climate change allowances for the catchment as set out by the Scottish Environment Protection Agency?
So it's not addressed specifically in the wording of the condition as written at the moment. However, I would note that it requires agreement with SEPA in due course, and one would expect SEPA to seek and apply whatever the latest position may be in relation to climate change allowance, and that would inevitably be applied. So our position would be that it's not necessary to add that detail to the condition wording as it is at the moment.
Again, Mrs. Knox, do you agree?
Yes, sir. Thank you.
In terms of condition 7, would any scheme allow for investigation should there be a suspected contamination or interference with any private water supplies? Mr. McGovern.
Yes, sir. Again, that is not expressly referred to on the face of the condition as it's worded, although one would envisage that any such scheme would provide for monitoring and for the investigation of complaints should any such complaints arise. I don't think we would be strongly opposed if you deemed it necessary to make that clear in the wording of the condition, but equally, I suspect that would be a matter that the council would seek to have addressed in any scheme that's put forward for approval in due course in any event, sir.
Mrs. Knox, is that the case?
Yes, the council agrees, sir. Thank you.
I suppose for yourself, Mrs. Knox, to begin with, on condition 8, are you content with the micrositing allowances and also for delegation to the Ecological Clerk of Works?
Yes, sir. The council satisfied. Thank you.
I obviously assume that the appellant is also satisfied with the wording of that condition.
Yes, we are, sir.
Are there any comments in terms of conditions 9 through to 20? Nope. Okay. In terms of condition 21, I'll just let me get down to it. There's a few options here and commentary from the council in relation to installation, review of whether or not ADLS system could be imposed. Is such a condition necessary, and indeed is it enforceable? Mrs. Knox first, thank you.
It's the view of the council that the condition is necessary because it would secure the best form of mitigation, visual impact mitigation for the development in the long term. And it's also the council's understanding that there's a reasonable prospect of this technology becoming available or approved in the not too distant future. So we would consider that it is reasonable, sir. And we also consider that it is enforceable as well, because we would be able to ask the applicant for a copy of their review.
But in terms of enforceability of actually imposition of an ADLS system, is that possible?
Sorry, sir, do you mean ensuring that it is installed?
Yes.
I think that the council could ensure that it was installed. I think it is enforceable, so.
Okay, Mr. McGovern, I'll ask you to come back on that, and then I have a subsequent question.
Yes, sir. We take the opposite view in relation to this condition. The applicant is obviously aware that ADLS has been proposed elsewhere and that there are trials looking at this solution, and there may be some optimism that in the future this solution may be CAA approved. However, the fact remains that the CAA has not approved the use of any form of ADLS at this time, and we don't know if or when any such approval may be forthcoming, and we certainly don't know on what terms any such technology may be approved, and whether the terms and nature of the technology as it is approved would be suitable and capable of being deployed at this particular site. ADLS is therefore not a mitigation which is reasonably available to the applicant at this time, and it therefore follows in our submission that we've done everything that we can reasonably be expected to do by way of mitigation in terms of the nature of the lighting that is proposed to be secured in this particular scheme. Whatever optimism there may be about ADLS coming forward, in the absence of it being approved as we sit here today, sir, in terms of your consideration of the impacts of night lighting, you will have to assume the worst case scenario, that ADLS may not be approved and may never be deployed at this particular site, and you will have to reach your conclusions based on that worst case scenario. And if in your judgment, sir, and in the judgment of the ministers, the impacts of nighttime lighting are found to be acceptable in the absence of ADLS, then I would suggest it cannot be considered that such a condition retrospectively requiring its application would be reasonable or necessary, sir.
Yes, that leads me on to my question back to yourself, Mrs. Knox, about if in a theoretical position I was to find that the current mitigation was acceptable and recommend that ministers adopt that approach, why then would we impose something further down the line? Sorry, you're on mute.
Sorry about that. I think that's something for you to consider, sir. Obviously, if ADLS were to come into force further down the line, it would, in our opinion, offer the best form of mitigation for this development. And that's the council's position, that we would always seek to have the best mitigation possible.
Yes. Sir, if I could chip in there as well, please. I echo what Mrs. Knox has said, albeit Mr. McGovern is quite correct. You will assess on the basis of the worst case scenario, and this would then present a mitigation further down the line after grant of consent if that was a decision of yourself and ministers. That's all understood. But this is a condition that is being suggested by the local authority, the planning authority, in order that the maximum of mitigation can be assured, notwithstanding the basis on which consent is granted. Now, the first point that Mr. McGovern made was that, as sitting here, we do not know that there is CAA approval for any such scheme. And I might add that this was a matter that was canvassed extensively in the Narrachan inquiry. And again, that is also accepted. But there is nothing in legal terms preventing you from adopting or recommending such a condition if you're minded to do so. And I refer for guidance of that at paragraph 38 of Circular 4 of 1998. If I could just ask you to have a look at that. It's co-production number is, it's been recently corrected by Mr. McGovern, and it should be circular CD 2001. That was originally model conditions. That's now been corrected, and I think Mr. McGovern circulated the actual circular itself yesterday, very helpfully. And paragraph 38 of that, it has a discussion there of conditions in a negative form, which of course this would be. Except there's a slight variation. It's not truly speaking a Grampian condition, as that term's understood, because it's in no way seeking to prevent any development until a condition is purified. What it's seeking to do is to allow for mitigation to be applied later on down the line, as and when it's feasible for it to be done. So it's different to that, but nonetheless, it's the stronger case of the Grampian condition is lawful, as we know, has been since 1984. But this is a lesser form of that, and is also therefore lawful, given that the greater includes the lesser. Paragraph 38 of the circular discusses negative conditions under reference to also, apart from obviously Grampian Regional Council against Aberdeen District Council, but also makes reference to British Railways Board against the Secretary of State of the Environment in 1984. And I can tell you that that authority is good authority and is good in Scotland, because it was followed in Strathclyde Regional Council against the Secretary of State for Scotland in 1996. So it's perfectly lawful for you to take that approach. And so what then therefore is sought to be done by way of the condition is to accept that there is no agreement with the CAA at the moment, and there is no aircraft lighting, I think, that has been approved. I think that was clear from the Narrachan inquiry. But as and when a system is in place whereby it is technically and regulatory, it is feasible and technical and regulatory sense, that is something that will be introduced in order to provide lighting mitigation. And funnily enough, there is other guidance that it's very, very brief guidance, and it's not included as a core document, but it perhaps doesn't add much, and so I wouldn't ask that it be added as a core document, but it's a 2012 guidance which states as part of it is guidance on dealing with aviation and associated negative conditions in wind turbine consent. So it is opposite to what we're talking about. And it has one paragraph that's of note, which says that evidence of the likelihood of a technical solution being realised within a reasonable time frame will be a relevant consideration in deciding whether or not to give consent with negative conditions to address aviation issues. So that's as much as I would take from that particular guidance. It's quite old, obviously, but that's actually very pertinent to what I'm talking about. So there is.
Sorry to interrupt you, Mr. O'Carroll. Who produced that guidance?
It's Scottish Government guidance. Scottish Government guidance from 2012, sir. I apologies for overlooking that, but it is incredibly brief. I've tried to see if there's a PDF format, but when you look for it, it just comes up as a Word document or as just a narrated web-based page. But it's guidance on dealing with aviation and associated negative conditions in wind turbine consents. So it has that one paragraph that I mentioned, that it is relevant for you to consider whether there will be a technical solution within a reasonable time frame. And I think we're in that territory. I think there are, as I understand it, technical solutions being developed all the time, and that is something that would be might well be something that could be produced in the future. So, for the reasons stated by Mrs. Knox, and as in fact narrated in the reason suggested in the condition provided by the council under this heading, I suggest that it would be not only legally competent, but also desirable for you to impose such a condition or to recommend such a condition in the event that you are minded to grant consent. to recommend the grant of consent. Thank you, sir.
Thank you, Mr. O'Carroll. I think it'd be useful if you could either screenshot or PDF that guidance you're talking about and submit it as a core document now that you've referred to it. Mr. McGovern, any response to what you've heard Mr. O'Carroll saying there?
Yes, so just a few further observations. Narrachan was referred to by Mr. O'Carroll. Of course, we don't yet know the outcome of Narrachan, and we don't know whether the condition as proposed by the council will be attached to the Narrachan consent. I'm familiar with the guidance that Mr. O'Carroll's referred to and the case law around the use of grampian conditions, and I wouldn't take issue with what's being suggested there as a matter of law. I would suggest, however, that I'm not sure that advice and guidance is necessarily of assistance in this case, because as Mr. O'Carroll suggested, this is not a grampian negatively worded condition that precludes development from commencing. It imposes a positive set of obligations to review the position at set frequencies, and in the event that ADLS is approved, it imposes a positive requirement to seek to install that. So it's not a condition formulated in the way that guidance and case law relates to, sir. So I'm not sure that is of assistance. And finally, my final point would be that regardless of the lawfulness of imposing such a condition, I would submit that it still remains that you will have to consider a scenario where there is no ADLS, and you will have to reach a view on the acceptability of that. And if your conclusion recommendation is that scenario is acceptable, then I would still fall back on my earlier remarks that in terms of the policy and the circular that you referred to, the condition in that scenario and in those circumstances would be neither necessary nor reasonable.
Mr. Fraser.
Thank you, sir. I'm not going to go back over the matters that Mr. McGovern covered, because he's raised, I think, the points I would. It's just a very small point. It may be that I'm looking at the wrong document. My version of core document 10014, I note that in the council's proposed condition, there's subparagraph numbers, but there doesn't seem to be a subparagraph 3. Is that just a typological error, or am I missing something in my what is all I'm really asking? You'll see it goes from 2C to 4. Obviously, if it's a typographical error, that can just be, it can be cleared up. But I have to say, if I had been dealing with it myself, I would have been saying exactly the same things that Mr. McGovern has said about the merits of the matter, sir.
Thank you. I'll just get confirmation from Mr. McGovern. Is that a typographical error? I don't see reference to 3 elsewhere in the condition. Sorry, Mrs. Knox, because it was yourselves that promoted this particular condition.
Thank you, sir. Yes, that would appear to be a typographical error.
Right. Mr. McGovern, in terms of best practice, if a form of ADLS came on stream down the line, would a wind farm operator look to install that?
So I think any responsible wind farm operator would always be mindful of looking to mitigate their schemes and in line with best practice at the time. So in the future, and you're asking me to speculate now, in the future, if CA's approval is in place for a scheme and it is technically feasible and viable, then I'm sure that would be looked at. But again, I go back to my earlier submission so that we're not in that situation just now.
I suppose I'm just trying to understand, are there industry standards for wind farm operators where they would have to apply best practice? And so if this particular technology was approved, there might be an onus to install it.
So I'm not aware of any industry standards at the moment which would impose a requirement on any particular operator to install aviation lighting. It would be a question on a case-by-case basis in light of the impacts as to whether that particular form of mitigation is something that would be deployed.
Thank you. And finally, on this matter, are parties aware of this condition being imposed in any other case? Mr. McGovern.
So I'm aware of it being proposed, and Narakan's an example of that. I confess I'm not familiar with any conditions where Section 36 consents where this condition wording has been attached by ministers, but I confess I've not gone through all of the decisions that have been issued. So it may be that the council can direct you to an example of this.
Mr. O'Carroll. Your microphone's off. That's the reason I'm wondering if you're coming in.
I wasn't. I have nothing to add to what Mr. McGovern said. Maybe Mrs. Knox might be aware of another decision another case where it's been suggested. I do think it has been suggested. I think my memory, and it's only a memory, and I think Mrs. Knox might help me out, but my memory from the discussion I had with my landscape architect was that it had been suggested in other schemes and was becoming a growing trend, since obviously this is part of another trend leading to more ADL aircraft lighting because of the ever-increasing height of turbines. So it's clearly an issue that's got legs and there's somewhere to run, and it needs to be addressed now in terms of these earlier schemes coming through over 150 metres in height. Now, I'm just giving you the summary of my understanding from my discussions. I wonder if Mrs. Knox might think of any other schemes in particular to help you with specifically. That's as far as I can take it, I'm afraid.
I'm afraid I can't think of any schemes at the moment. I know that it was we have proposed it for Narakan, and I know that similar conditions have been proposed elsewhere, but the names escape me at the moment, sir. I'm sorry.
I just ventured to suggest, I think at the time, Landscape Architect had just been dealing with inquiries up in Highland. I think there might have been some recent cases being heard up there. But anyway, the long short of it is, I cannot tell you of any such case where it has been imposed. All I can tell you is that it's being suggested, and it's obviously these are early days for it, for the reasons I've stated.
Okay, many thanks. I'll come to a view on that myself. Now, does anybody have any comments on conditions 22 to 28? No. In terms of conditions 29 and the alternative and condition 30, we discussed those on Tuesday. And of course, I will be issuing further written submissions on noise conditions in due course. Those will likely come out next week after the inquiry and when the case officer's back at work. If we move on to the definitions, are parties all content with the definitions that are proposed? Mr. McGovern?
Yes, sir, we're certainly content.
And Mrs. Knox?
Yes, sir. Thank you.
And moving on, well, are there any other comments in terms of the conditions that will be applied for the deemed planning consent? No. Moving on. Oh, yes, Mr. McGovern.
Sorry, sir. Something before you move on to your last agenda items, it's something I should have raised actually when we were discussing the aviation lighting condition just a moment ago, page 21. It's come to the applicant's attention that our proposed condition wording does need to be adjusted slightly because it cross-refers to Appendix 16.1, which is the aviation lighting scheme proposed by the applicant. And at the time that scheme was written, it was proposed to light 8 of the turbines, and you'll be aware from the evidence that's been given that that has subsequently been reduced to 6 turbines. So there is a need for a correction to the wording of that condition just to reflect that it will be 6 of the turbines that will be lit, but otherwise the lighting deployed would be as set out in the aviation lighting scheme that forms Appendix 16.1.
Okay, so do you have a form of words, Mr. Govan, that you'd like me to insert?
It may be simplest, sir, just to add in reference to the particular turbine numbers on which the lighting's to be installed. So the first line, as amended, could say aviation lighting must be installed on T1, T2, T4, T10, T13 and T14. Otherwise operated in accordance with the scheme.
Are you in agreement with that, Mrs. Knox?
Yes, sir. Thank you.
Just quickly confirm with parties that the legal agreement or planning obligation is not required in this case. Is that correct, Mr. McGovern?
Yes, sir. That's certainly our position.
Yeah, Mrs. Knox?
Yes, sir. That's the council's position too.
Okay. Are there any other relevant matters to do with the conditions that I should be aware of?
Yes, sir.
Oh, thank you. Right, well, that ends our hearing session on conditions and indeed ends all of our oral sessions to do with this inquiry. So I'd like to thank all of you for participating throughout the week. You can obviously review this footage back on the DPA webcasting site if necessary. For yourself, Mr. Fraser, Mr. O'Carroll, we agreed the dates for closing submissions on Monday, and an email has gone out to that effect. And also your summaries of case, and you both told me on Monday that you were content with those summaries as set out in the pre-examination meeting note. Are you you're both happy with that approach? Mr. O'Carroll?
Yes, sir. Thank you.
Mr. Fraser?
I am, but I suspect it's Mr. McGovern who's going to be busy working on the summary, so I better just check he's happy, sir.
Yes, sir. I'm very happy with that also. Thanks.
What you mean, I think, sir, is you're talking about the template for the summary that's produced along with the note.
Yes, so I'm looking for one template, one submission per oral session. So I will summarize what's in writing in terms of all the other EIA chapters and issues. But for those matters that we've had oral sessions for, so policy, noise, landscape and visual and conditions, if you can provide a separate summary of case for each of those and within a reasonable word limit, which is set out in the pre-examination meeting. And then in effect, when I write my report, instead of as traditionally I would summarize parties' cases, I can instead refer to those summaries, and that should make the process more efficient, and also it will allow you to provide your summary of case rather than me summarizing your case, if that makes sense.
It does. One thing I do find though is that as with all templates, it's hard to, it doesn't cover everything, every eventuality, and sometimes it's not apposite, but I take that on board and we'll do the best we can.
Thank you, much appreciated. I mean, sorry, Mr. O'Carroll, you want to come back?
No, and I was just going to say thank you very much for your good humour and very efficient running of this particular inquiry.
Thank you, appreciate it. Well, thank you to everybody. In terms of other matters, at DPA, we have a 50-week target now for us to submit our reports to Energy Consents Unit. Now, that would take us to week commencing 8th of April. However, if you are producing succinct closing submissions and summaries of case that I can refer to, then I would hope to have my report finalised earlier than that and submitted to ECU. And indeed, I will inform parties when I've done that. And indeed, I may inform you as I go along in terms of progress. We have the accompanied site visit in January as well, so I'll see some of you there. And as I say, there'll be one further written submission going out to do with noise conditions. Are there any other points from parties? Mr. Fraser first.
No, except I'm sure on behalf of myself and Mr. McGovern and everybody else, we'd join with Mr. O'Carroll's thanks to you, sir. Thank you very much.
Okay, well, much appreciated to all of you, and I'll no doubt see you again. Thank you.
Thank you, sir.
Thank you.